Good afternoon, everyone, and thank you very much for joining us today in this exam preparation session for candidate attorneys who are writing the competency-based examinations on the 21st and 22nd of August 2024. I can already see that there are 1,000 of you online, so thank you very much for being with us today as we go through the syllabus and what is required of you for the upcoming examinations. Please note that this session will also be put onto YouTube afterwards, after we've completed today, so that those who are not able to join, or if you think you've missed something and you want to listen again, you're welcome to go onto YouTube and listen to the recording. To introduce myself, I am Melissa Murray. I'm the Senior Manager for Education and Training at the LPC. With me in this session and the presenters for each of the papers are Mr. Thomas Minnie, Mr. Preeth Singh, Ms. Hajira Kara, and Mr. Ashwin Trikhamji. I'm going to just give some introductory comments and then we'll hand over to our presenters who will take us through each of the exam papers. Please note that registration for these exams has closed and no late applications will be accepted at this stage. The purpose of this session that we've set up today is to go through the syllabus document and to ensure that candidates know what to prepare and how to prepare for the August examinations. Please note that the syllabus applies to the August exams, which are 21 and 22 August. An updated document will be shared for 2025, but at this stage, your focus needs to be on this document that was emailed to all candidates last week and has also been placed onto social media. Let me start off by clearing some of the confusion relating to this examination syllabus that was published last week. Firstly, it's not a new syllabus. There are no new documents this document is not a new syllabus that's been sent to the candidates. The exams have always been conducted in terms of Rule 21.1 and 21.2 and Regulation 610. I know a lot of candidates have written on social media or have written to the LPC stating that this is a new document, but please note that it's not a new syllabus. It is a requirement for your admission as an attorney that you complete the program of structured coursework, which is in Regulation 610 specifically, where the modules are. And then you must pass the exams or the assessments relating to those modules. So if you have a look on the front page of the syllabus document, where we have set out for you exactly what the rules are relating to the assessments, and then you'll see at the bottom of page 1, the different topics that are covered in each of the papers. Now, this is to cover all the modules that are listed in Regulation 610. All of these modules form part of your examinations. So like I said, it's not a new syllabus. It's what you should have been covering for all the previous examinations as well. But what we have done in order to assist you with your preparation was to break down each module into what candidates need to know per exam paper, so that you can focus your time and attention on what you need to prepare for the exams. This also assists you so that you don't focus on any modules or topics that are not going to be covered in the exams. Anything that is not in the syllabus document will not be in the exams. And we have checked with the drafters of the exams to make sure that there isn't anything outside of this document. And for example, many of you may have noticed that insolvency law has not been included in these exams. So you do not need to go through that guide and learn for insolvency, as it won't be covered in these exams. Any other topics not expressly stated in the syllabus also won't be covered. And this is to assist you as candidates for the exams. We know that it looks like a lot as you go through the bullet points for each of the different exams and the different modules, but you'll see that you already know a lot of these topics You can tick off as you go and ensure that you cover exactly what is expected and requested of you. Candidates have complained in the past that you didn't know what to study, you didn't know what would come out in the exams. So this document was drafted to give you more guidance and to show you exactly what it is that you need to prepare. All the questions for all 4 of the exam papers are from this syllabus. So you can rest assured that we're not trying to trick you. There won't be any questions from outside of the syllabus. Secondly, you will note that there has been an increase in the time allocated for each of the exams. So for papers 1 and 3, these are now 3-hour papers. Paper 1 has always been a 3-hour exam, but paper 3, the time has been increased to 3 hours. And papers 2 and 4, being the wills and estates and the bookkeeping papers, are now 2.5 hours each. This doesn't mean that the exams are going to be longer, but it is going to assist candidates to take time to properly apply your minds in the exams and respond to the questions. The additional time should help you not to stress and panic, especially what we've seen in paper 3. You need to take time, take a breath, and apply yourselves thoroughly in the examinations. So please don't panic when you see that there is a little bit more time that's been allocated to the exams. That is to assist you. You will need to plan accordingly when you sit down and you start the exam. There is still the 15-minute reading time before each paper, so you can go through the exam and then pace yourself, starting with the questions that you're most comfortable with. So this increase in the amount of time that's been allocated is to assist you as candidates. We know a complaint is often that you didn't finish or you were rushed, and this should assist you in answering the exams. Thirdly, the exams are not meant to trick you. So take your time and apply what you have learned. There aren't any trick questions. The questions are straightforward, and from reading the question, you will know what is being asked of you. All exam papers will be a mix of theory and practical or application type questions. So after learning the theory, you need to also learn how to apply what you have learned to a set of facts or a scenario that's been presented to you. So for each of the papers, you must learn drafting as well as the theory. Next, and very importantly, please do not rely on previous papers and memoranda. I know a lot of candidates think that we're trying to trick them by telling you to stay away from previous papers and memoranda, but please, you need to realize that there's a reason that we don't want you to run to pass papers. And there's a reason that we don't provide the answer guidelines to candidates. This is because studying previous papers and answer templates will put you at a disadvantage for these examinations. You must focus on the syllabus. The questions will be phrased in different ways, so relying on previous question papers will not assist you, and learning previous answers off by heart will put you at a disadvantage. So our advice is to stay away from these previous papers and answer templates and focus only on the syllabus that has been provided to you. Finally, before I hand over to our presenters, just a few points that you need to know. So if you've got a pen and paper with you, just make these notes. Remember to only write in black ink. So in the exam, make sure you take a few black pens and only write in black ink. Please do not use pencil. For bookkeeping, I know a lot of candidates think that they're going to write in pencil and then go back and write over it in pen. But please, we cannot mark pencil. So if you write a full answer in pencil, unfortunately, we cannot mark that and you'll get 0 for that question. So please write in black ink. Please do not use any other colors like red or green or purple, because the markers and the moderators use different colors when they're going through your scripts. So a marker, a remark, and on moderation, there's 3 different colors that are used. So please make sure you only write in black ink. Secondly, write only on one side of the page as instructed. For those of you who are writing for the first time, you'll see that only one side of the page has the lines. So please write only on one side of the page and read the instructions that are on each exam paper. In that 15-minute reading time, please don't skip over the instructions. They are here to assist you. Also, leave your Tipp-Ex or your correction tape, leave that at home. Where you make a mistake, draw a line through it and then start again. Please don't use Tipp-Ex as we're not able to mark something that you've written over Tipp-Ex. But these are all on the instructions that will be on the front of your question papers. So I'm now going to hand over to our presenter who's going to take you through paper 1, which is the court procedures and court practice paper. This includes high court practice, magistrates court practice, criminal court practice, and personal injury claims, which are motor vehicle accident or the RAF claims. This is Mr. Thomas Minnie. If you have any questions, we won't be able to unmute you, so you can't ask your questions, but you're welcome to comment in the chat box or the Q&A box. When we see comments there, we will address them as we go. If you're not able to ask your question today or you want to ask something after the session, you're welcome to email info@lpc.org.za. I'll repeat, it's info@lpc.org.za. If you email us, please in the subject line, just put that it's an exam query and it'll come through to one of us who can assist you. The provincial officers are also still dealing with some of the registrations that came in just before the cutoff date. So if you haven't received your registration confirmation letter yet, just allow the provincial officers until next week, and then you can follow up by sending that email to info@lpc.org.za. So now I'm going to hand over to our presenter, Mr. Minnie, who's going to take you through the syllabus regarding paper 1.
Thank you, Melissa.
Thank you very much, Mr. Minnie.
Good afternoon, everybody. Before we get started specifically on paper 1, I just want to draw your attention to a few things, and I'm talking the exam in general. You got to keep in mind, and you've got to sit down and take cognizance of the fact that all of you have reached quite a big milestone in your career already, and you should feel proud of yourself. And that pride and taking ownership of the fact that you're now going to go write your exams is all part and parcel and the beginning, the seed of writing good exams. Be proud of yourself and take control of what's about to unfold. It is an honor, and you should, like I say, feel proud of yourself and what you've achieved up to now. In respect of the exams, the biggest, if I can call it, mistake that we find students making is it's clear that they simply don't read the question. The questions, as they say in the classics, the devil lies in the detail. Read the question. The most important time that you will spend on an exam paper is not the 3 hours you'll have to answer it. It is the 15 minutes that it will take you to read the paper. The purpose of reading the paper first and taking the 15 minutes and diligently reading the questions is what it does. It starts stimulating the juices in the grey matter. And the process of then thinking in legal terms takes control in your thinking process. And this is the starting point that enables you to sit down and concentrate on what you are going to write in your paper. So to just fly away and think that you're going to save some minutes is detrimental. And at the end of the day, it doesn't serve any purpose, and it actually just is a negative effect on what is presented by the students. Okay, so take your time. Don't panic. Read the question. The examiner has asked the question and they want a specific answer. You find that plenty of students write brilliant answers, but it doesn't address the question. And then unfortunately, it's a zero. And all your effort goes to naught because it's not what the examiner is looking for. The examiner, in examining a legal student, you want to know that the student can take a set of facts and apply the set of facts to the legal process and the theory as in the current situation as it stands in South Africa. So think about what the examiner is asking you and what he wants to test. Many times, if you look at what the first and second sub-question and third sub-question, it should give you an indication of where you should be on the first part and what the actual question deals with. Okay, the questions are not difficult, but they are very specific. Right. As far as paper 1 is concerned, you'll be required to know the 4 topics: the High Court procedure, Magistrates Court procedure, motor vehicle accidents and claims, and then, of course, the criminal court procedure. In as far as the High Court and Magistrates Court procedure is concerned, it's actually quite astounding how many students write the exams which are now going to take them into the profession and still do not understand the basic differences between an application and an action. Ladies and gentlemen, those are basic skills that should have been acquired in your first year at university already. It's very simple. We're dealing with two major principal kinds of civil litigation. We use the application procedure and we use the action procedure. When an examiner refers to application deals with affidavits. It deals with an applicant and a respondent. We find so many times that students they draft an application in the form of a particulars of claim. An application gets signed at the end of it by a commissioner of oaths. It is what you state under oath. It is therefore written in the first person. And the parties to an application, as I said, is an applicant and a respondent. It's not a plaintiff and a defendant. In action proceedings, we have a plaintiff and a defendant. And there, you have to make out a cause of action. So your particulars of claim must address those aspects of your claim to give you a
He's gone off, Melissa. He's gone offline.
Thank you very much. I apologize for that. Just allow me to try and get Mr. Minnie back online quickly.
There we go. Can everyone hear me?
We can hear you. Yes, please proceed. Thank you.
Okay. Sorry about that. I don't know what happened there.
Thank you.
Okay. So remember, when the question deals with applications, then you must talk in application language. We're talking applicant, respondents, affidavits. And when you're talking in an action, then it's plaintiff, defendant, and particulars of claim. Then the rules of court. Ladies and gentlemen, it is clear when the students write the exams that they have not gone through and understood how the rules of court work. Our legal procedure in South Africa is run by our rules of court. If you do not follow the rules, it can be fatal when you are in practice one day. So you have to understand which rule is used. Rules are there so that everyone complies with the same set, so that there's no advantage between one party and the other. Keep in mind that there's always a rule to make sure that the process doesn't stop. There's always a way for any party, whether it be the applicant, the respondent, the plaintiff, the defendant, it doesn't matter. You will always be able to drive the process forward by using the rules. A very common question that's normally asked, and you find it plenty, is you use it in practice every single day, is the application to compel. What's it used for? A party gets to a certain point of the proceedings and they must now make discovery. Now they don't. If they don't make discovery, you can never go to trial. So there's a mechanism. We compel them. You bring an application. Now that application, you can see now, is in the context of an action. There is a dispute between the parties, and now you want to go to trial, but now you have an application. So you can see that many times the application proceedings is interwoven and takes part within the process of an action. And it's important to understand that issue as well. And we refer to that as interlocutory applications. Okay. Then there are certain applications that you find all the time. And I can mention one of them, which is a favorite, and you'll use it a lot. It's a question that has come up in past exams. As Melissa said, don't go look at those. But for purposes of preparing for these exams, what is a spoliation application? Mandement van spolie. What is it? How does it work? Who uses it? Because those are the questions you'll be asked. Because if you bring an application for the mandement van spolie, you have to know that your client, who is going to be the applicant in the matter, will fulfill the requirements in order to be successful in court. Okay. Anton Pillar orders. When do you use them? Why do you use them? That's the important aspects you must consider when preparing, because that's the way the exam will be asked. You'll be given a set of facts. You then have to understand, this is the application they're going to be bringing because these are the facts. So it's under this condition, under these conditions, that will require this application. So you must, besides studying the theory and understanding how it works, you have to know when it will be utilized. All right. Special pleas, urgent applications. Urgent application. Students in the past, they have been asked the question of urgent applications, and they simply do not know. The very first obstacle you have to overcome when bringing an urgent application is to ask the court to condone the non-compliance of the rules. We've now discussed that. There are rules that everyone complies and everyone lives according to the same set of rules. Now you bring an urgent application and you deny the opponent the right in terms of the days. You must convince a court that detraction from the rules is validated, that you are entitled to it, and that there is good reason for the court to entertain it. All right, so go study how urgent applications work and under what conditions you are allowed to bring them. Difference between reviews and appeals. What is reviewable? What is appealable? Go look at some of the differences there in the rules. You'll see that there are judgments. How do we rescind the judgment in the magistrate's court? And under what conditions can we rescind the judgment in the magistrate's court? And then, is it the same in the High Court? Can I bring an application in the High Court under the same reasons for rescission of judgment that I did in the magistrate's court? Does the rules allow for such an application? And as I said, the extension of time periods, the amendment, Rule 28 amendment, very important. And then, of course, the non-compliance with the rules. What happens when you do not comply with the rules? Ladies and gentlemen, then, of course, special pleas. That question has been asked in the past as well. You've got to understand what they are, when they are used, and how do you make use of them? Do you lodge a special plea in the course of your pleadings, or is it something that you can do on its own? And when do you make use of a special plea in respect of the process? So will I do it at the beginning of the trial? Will I do it at any time that it manifests, etc.? So understand exactly when and where and how a special plea is used, and then of course how you draft them. They're not difficult to draft. It's an extremely simple document, but each one of them you have to state the specific aspects that needs to be addressed for you to uphold that specific special plea. For example, if you're drafting on prescription, then you have to address the issue of time. So then all the dates relevant to that specific plea, the special plea of prescription, you have to then state them. On what date was the summons issued? What date was it received or served? What is the date now? When was the defense given? When was the plea due, etc., etc.? So that's the important part. If you're talking about jurisdiction, you've got to set out the jurisdictional issues. For example, where was the contract concluded? Where did the damage take place? And whatever you're going to base it on, you have to address that in your special plea. Okay, so it is plea specific, if I can call it that. Right, then as far as the Magistrates Court, that's now the High Court and Magistrates Court together. But then as far as the Magistrates Court is concerned, specifically, you must go and have a look at mostly those procedures that you deal with every day. Rescission of judgments, summonses, spoliation applications, all of those are dealt with fairly regularly. When must a person defend a matter? What happens when a person doesn't defend a matter? What happens when a person does defend a matter but then doesn't plea? So each one of these will give rise to one of the rules kicking in, and the mechanism according to the rules of court will then drive the process forward. You have to understand how those rules plug into each other and how they regulate the litigation process for both action as well as application proceedings. Right. Then with regards to motor vehicle accident claims, the only thing that I can tell you about the motor vehicle accident claims is an extremely easy section to get good marks. It is not a lot of work. There is basically one act that regulates the entire system, and it mostly works on prescribed timeframes, forms, what must be given in, what mustn't be given in. And then if you understand the allegations to be made in respect of litigation in a claim where an accident falls within the ambit of the road accident fund, once you understand it, it's done. It will never change. It's always the same. Remember, the road accident fund is an exception to the rule where the wrongdoer is sued, is held responsible. Okay. So do not, when you're drafting documents and processes for purposes of road accident fund, and many times the students get it right. They say, who's responsible? They say, no, it's the road accident fund. But then when you ask them to draft a particulars of claim, they then draft it in the person that caused the accident. the allegations of the person that caused the accident must be inside the particulars of claim. But the party that is being sued is the road accident fund, because the road accident fund is liable. So understand how that process works exactly and specifically. It's the driver's actions that are referred to, but the driver's actions gives rise to the road accident fund being liable. And that distinction needs to be demonstrated in the way you draft your pleadings so that the examiner can clearly see that you understand how this mechanism in the South African context works. Right. Which pleas can the road accident fund offer if a party sues them? What are the as I said, the time frames? What when may I claim? What amounts? For what may I claim? What falls under special damages? What falls under general damages? And what must I prove? And what documents must I have in order to claim under those specific heads of damages? That many times goes hand in hand with the citation of parties. What happens when a minor is injured in a car accident, and it falls within the ambit of the road accident fund, who takes responsibility for the litigation in such an instance? Okay, so as far as the motor vehicle accident claims are concerned, it's not a difficult component of the work. It's very straightforward. Inside the motor vehicle accident, you will find an overlap once again. That is where you normally find different types of fees being arranged between the claimant and an attorney. What does the law say? What fees may be charged? What's the maximum you can charge? How does it work? What does the law say with regards to the fees that you are entitled to charge as an attorney? And when are they payable? Then, in as far as the criminal procedure is concerned, yes, the Criminal Procedure Act is quite lengthy. It's a relatively lengthy document, but the stipulation that's been given specifically in this document that's been prepared now by the Legal Practice Council, and I must tell you that I think that the way that this has now been set out makes it far more easier for the student to understand and to pin the corners of what they need to study for the exams. So there's not much further that a person can add to these, to what's been stipulated here, because having regard for the material that I've seen that you've been given, the different statements, plea explanations, etc., are all set out in examples that are in your possession. There are just a few things that I want to touch on, though. And one of them is bail. If you ever look at section 60 in bail, when students are confronted with a question on bail, they all use what we refer to, well, let me speak for myself, what I refer to as the blanket approach. They simply all refer to those aspects that the court will take into account when considering whether bail should be granted. Now, if you go and look at section 60 and understand how the mechanism of bail works, and I'm briefly going to take this opportunity to explain it to you because it's important and students never ever seem to understand it correctly. The first component of section 60 states which aspects a court will consider. Then when you go further and you read rule 60, section 60, it then takes each one of those aspects and then breaks them down further. So when the court considers the first aspect in a bail application, whether it will give or grant bail or not, in considering that aspect, it takes 8 or 10 other factors into account. Then when it takes the next aspect into account, it takes 8 or 10 other factors into account. And it's important to understand that each one of those are different. Yes, there is huge overlap, but they're not all the same. And like I say, the students in answering the question generally just answer the aspects the court will consider in granting bail. And it's much more specific than that. So make sure you understand exactly how bail works. Because if you are asked a specific question on maybe just only one of the components of a court's consideration, then you'll be required to answer the second leg, which is those numerous aspects which the court will consider take into account in considering whether that specific aspect is addressed or not. And then with regards to the different pleas, it's very important to understand the different pleas that a person can offer. And and then of course the issue with regards to arrest. When can a person be arrested and why? Why is it possible for a person to be arrested, for example, without a warrant? Under what circumstances? And when will this normally take place? Okay, then a very important aspect, also students get mixed up, and it's important to understand the difference between an appeal and a review. What is appealable? When is it used? And what is reviewable? And when is it used? And what is the effect when an appeal is lodged on the further proceedings? And what is the effect of a review in the process? And then as far as search and seizures, that's a very important component that you will deal with in your career if you deal with criminal matters. And then the last three there are three fairly new, if I can call that newish, considerations that need to be considered. You need to go and have a look at those acts. It's important because those three acts at the moment, especially the prevention and combating of corrupt activities and the prevention of organized crime, is two of the acts that are playing a big part in driving our current criminal procedure and our case law. So it's important to have regard to those two specific acts. Yes, then I don't think there's anything further from myself. I just want to once again go back to where I started, and that is, ladies and gentlemen, read the question. If the question relates to an application, make sure you talk application language. If the question relates to action, make sure you're talking action language. If the question relates to a motor vehicle accident, it's not necessarily the road accident fund. The road accident fund is only liable for personal damages. If a person's car is damaged and they want to claim because the bumper's bent and the headlight is missing, it does not fall in the particulars of claim and is not addressed when you're talking road accident fund. It's not relevant. That's a civil action. Motor vehicle accident can also give rise to criminal activity. You can be charged with reckless negligent driving, for example. You can be charged with culpable homicide. There are numerous things. So those three aspects you can see all can come from one occurrence in South Africa. Motor vehicle accident can relate to all three of those, and don't get confused when you're asked a question and the question relates to damage to a vehicle or criminal procedure or something to that like. It's concentrate on what is being asked and address the question. All right. Then from our side, all that remains is for me to wish you the best of luck, and we'll see what happens. But concentrate, and you should be good. Thank you.
Perfect. Thank you very much, Mr. Minnie. I'm just having a look through the comments, just if there's any for you specifically on paper 1. But thank you very much for taking the candidates through what's expected. As we said, it's the 100-mark paper. There's 25 marks for each of those 4 sections that have been covered. So please, all candidates, make sure you cover all 4 of those sections. Please don't leave anything out. I've got some comments here where it says, do we need to draft the pleadings? For all of these topics, you do need to know how the theory and drafting for everything that is on the syllabus document. That is the only comment that I can see regarding this session. Thank you, Mr. Minnie. I think that's all the comments we have for you. If there are any others, I will ask you. But I think that's it for you today. Thank you very much, sir. We do appreciate your time.
Melissa, if there's any comments, sorry to interrupt. If there is any comments that need specific, you're more than welcome to email it to me, and I will give a response. Okay.
Thank you very much.
Thank you very much, and to my other colleagues that are going to do the other 3 papers. Have a good afternoon, and thank you very much.
Thank you very, very much, Mr. Minnie. We appreciate your time.
Goodbye.
Thank you, sir. So if there are any specific questions, please email info@lpc.org.za. Obviously, we can't give you anything that's in the paper. It's not that kind of assistance, but if there is any specific questions, you email us. You can put attention Melissa, and then we will get the relevant assistance for you. We're now going to move on. Our presenter for paper 2 is just having some connection issues, so we're going to move across into paper 3. I'm going to ask Ms. Hajira Kara, who's ready to go on paper 3. If you can unmute yourself and go ahead. Before we start off there, if I can just refer everybody to the syllabus document. So you'll see that this paper is now, like I said, a 3-hour paper. It doesn't mean that this paper is now going to be packed with a lot more, that you're going to run out of time. The 3 hours is meant to assist you, to give you more time to apply your mind, and to think carefully through the questions before you answer. If you need to, you can make notes on your question paper. You can structure your questions and your answers before you write them. So please take your time. That's why we've extended the time. A lot of candidates in the previous exam said that there wasn't enough time, and we are therefore giving you the time that you need. Also remember, in this paper 3, it is also a mix of theory and drafting. So you will need to make sure that you're able to draft and take the time that you need there. This paper, as I hand over to Ms. Hajira, this paper is made up of 9 different topics. It does look like a lot, but if you have a look at what's expected of you, you'll see we've been very detailed. So, for example, when we go through, you'll note that anything not listed in those topics cannot be examined. So just know that we've done this to assist you. Yes, it is a lot to be covered, but I think the guidance in the syllabus will definitely take you forward. So I'm going to hand over to Ms. Hajira Kara, who's now going to take us through paper 3. Thank you, Hajira. Can you unmute yourself, please, and go ahead?
Thank you. Good afternoon. I think from the onset, it's important for us to understand that when we think of paper 3, you, to a certain extent, as candidates, already come into the exam with a negative attitude.
As a presenter.
I think Melissa forgot to mute herself. Okay, there we go. So it is important that you when you write this exam, you appreciate its mind over matter. You have paper 1, you have paper 2, this is paper 3, and you have paper 4. So it's important that you go into there with a fresh mind. Now, when you look at paper 3 and when you look at these exams, we must appreciate that this is an assessment of you as a legal practitioner. Now, in evaluating your assessment, and I'm not saying testing, because when we evaluate, the test is basically to see, as a legal practitioner, how would you deal with this? How do you deal with ethics in your day-to-day practice? So when you write paper 3, you need to look at yourself, put yourself in the shoes of a legal practitioner, and ask yourself, how would I deal with this in practice? So it's not your examiner doesn't know who you are, where you are from, what practice you are in. So it is you assessing you as a legal practitioner. Now, you cannot assess a legal practitioner without ethics. So the code of conduct is important because that is our rule book. It tells us how to be attorneys. The syllabus you will see is specifying certain sections you need to read through, but you cannot be a legal practitioner without looking at the code of conduct. I mean, that basically tells you what it is we can do in practice, what we cannot do, what are the consequences of what we do. It relates to our professional conduct as well as we assess in terms of your professional life, how you are as an officer of the court, your relationship with clients, with society, and then we go on and it explains certain things in detail. So, for example, conflicts of interest, not only in establishing what is a conflict of interest, but in assessing you. When do you, as a legal practitioner, realize there's a conflict or there's a potential conflict? What are the preliminary steps you need to take? Confidentiality and legal privilege, the same. Ethical duties of an attorney related to the profession and the code of conduct. So, this is where I said you must look at the code of conduct. Of course, your Legal Practice Act, the ethical consequences of prescription, then your legal practice code of conduct in terms of what the code of conduct specifies, how we need to do certain things, in particular the definitions, misconduct, the candidate legal practitioner, juristic entities, approach in publicity, specialization and expertise, and generally the integrity in performance of our professional services. Also, there's certain things in terms of sharing fees, officers, the conduct of attorneys, disclosures and non-disclosures, conflicts of interest we have said. The second part of your syllabus deals with the constitutional practice. And you will see constitutional practice, including aspects of customary law, is part of your paper 3. You will also note paper 3 is known as attorney's practice. And it is known as attorney's practice because of the fact that in practice, you deal with things every day that touch on different aspects of law. So it might transpire that it's not that a question can also be not related only to subject matter, but related to how do you as an attorney deal with something ethically. So when it comes to constitutional law, it's including your aspects of customary law. We have the Bill of Rights, we have jurisdiction of the Constitutional Court, matters and access, as well as exclusive jurisdiction, your declaration of invalidity, reading down, reading in, severance, remedies available, advising clients about their constitutional rights, customary law, including land, customary marriages, the recognition of these, succession, ownership of property, and traditional leadership. You refer to constitutional cases on these topics as well, including the B judgment and others, and of course the Constitution. Now, in terms of labor dispute resolution, which is 3.3 on your syllabus, you of course have your dismissals, your disciplinary processes, notices and warnings, labor relations, including your CCMA, conciliation, arbitration processes, which include drafting, unfair labor practices and remedies, procedure and implications for strikes and lockouts, basic conditions of employment act, your occupational health and safety, and the unemployment insurance act. Then we have your alternate dispute resolution, which refers to or includes your defining and understanding of what a conflict is, the distinction between adversarial proceedings and facilitative, negotiation, conciliation, mediation, court annexed mediation in terms of Rule 41, the role of a chairperson or presiding officer in ADR proceedings, arbitration, role of ADR in litigation, the role of the mediator and arbitrator, ethics involved in conciliation, which would include your conflicts of interest, confidentiality, and mediator liability. Now, in terms of 3.5, we have your matrimonial law, which of course includes your marriages in and out of community of property, the effects of the accrual, whether they are worth or not, the effect of this on contracts, the Divorce Act, Matrimonial Property Act, and Maintenance Act, the advice on marriage and its consequences, your antenuptial contracts, divorce and its consequences, the principle of the best interest of the child, maintenance of children and former spouses, drafting your particulars of claim and pleas, customary marriages, Muslim marriages, care, contact, and primary residence of minor children. Now, remember your syllabus is a guideline. So we have, for example, your Divorce Act, your matrimonial, and your maintenance. We also must take cognizance of the fact that we have minor children, which means that in divorce matters where minor children are involved, you must take note of the consequences in terms of the effect this would have, for example, on minor children, and that comes in the best interest of the child principal. In terms of your legal costs, the content of a fee agreement, including the structure, the tariffs, and explanation of the various fee scales, how and when they are applicable, different types of fee agreements, including contingency fee, litigation funding agreements, costs in the normal course of litigation, non-litigious and civil litigious matters, the different types of fees that you can and cannot charge, factors that you consider, the various principles when evaluating fees, the rights of members of public and clients to dispute fees, as well as the processes for this, different types of court orders that the court can award, different cost orders in terms of like party and party, attorney and client, cost the bonus proprius, wasted costs reserved, all the different types of cost orders, the ethics related to overreaching and or undercharging, and of course taxation and related aspects, which would be the methods and the processes in terms of taxation. Now, when it comes to drafting of contracts, you must appreciate that when you draft contracts, you must take into account that because it's an assessment and it's because it's about you in practice as an attorney, you must appreciate that it's not only about the drafting, but it's how you would do it that makes it ethically correct as well. So that is an important aspect that you need to keep in mind when you are answering this paper. And because it's an exam, we must appreciate that there are sometimes questions that we might not understand or we have not seen. But as an attorney and understanding what I need to do in practice as an attorney means you need to sometimes think a bit creatively. So put yourself in that practical situation and ask yourself the question, what would I do in the circumstances as an attorney? What am I allowed to do? What is ethically correct for me to do? And then attempt to answer the question. So think about it in terms of practice. Apply the theory practically. Insofar as drafting is concerned, we have our deeds of sale, which relates to movable and immovable goods, introduction to contract law, in other words, the principles of drafting contracts, the difference between your essential material and natural terms, the drafting boilerplate or standard clauses, including parties, jurisdiction, confidentiality, non-variation, force majeure, dispute resolution, indemnification, and the likes. Then, of course, you get movable and immovable property sale agreements, including litigation drafts on such agreements and options to purchase agreements on immovable property, acknowledgement of debt and suretyship, power of attorney and mandates in terms of attorney and client, as well as natural and juristic persons, as well as the different types of mandates and contents of these agreements that can exist. Factors that you will consider when you draft a mandate, resolutions of a company, session, delegation and assignment, option as well as right of preemption, sale of business and sale of shares, lease of immovable and movable property as well. And you must also take into account that these are all different sections which all form part of paper 3. In addition to this, it's always good that when you are drafting and you're not sure about an answer completely, that you leave a few lines or your exam is not that you have to answer it in any specific chronology, so you can number them according to the answers you know. You have extra time on paper 3, which gives you more time to be able to evaluate, to think about the answers, and to apply your mind when you are doing them. Try as best you can to write legibly, because it's a paper that consists of various parts of where you write, as opposed to paper 2 where you're still doing accounting, or in paper 4 where you're doing accounting. In this paper, what you're saying basically comes from what you write. So if you write clear and legible, it makes it easier for the examiner to try and understand what it is that you were saying in that context. Okay, then if we go on, in terms of that, you have your letters of demand, cancellation of an agreement, conditions, employment contracts, of course, your credit agreement, National Credit Act, in terms of the syllabus, as well as your Consumer Protection Act. Now, the part that you are probably a bit, that's making you a bit anxious, I presume, is information and communication technology related to cyber law, as well as introduction to practice management, because you probably have the view that this was not in the previous syllabus, but in actual, this has always been part of your syllabus. Here you have a much more detail in terms of outlining the syllabus, because when you think about paper 3, it is everything in terms of the attorney's practice. So it would include, for example, your information technology for practice, associated cyber law, which is your Electronic Communications and Transactions Act, the security of personal information, awareness of protecting against fraudulent transactions, electronic documents and signatures, business email compromise, interception of payments from trust accounts. For example, electronic documents and signatures, there has been like exercises, there's been questions where you ask, can documents, related to that. So, and in terms of being part of the syllabus, it has always been there. You will also note that these aspects are also covered in your code of conduct, which means then that it is something that an attorney is expected to know, because it's for practice. So when we look at your introduction to practice management, we look at the regulatory requirements for legal practitioners with the Legal Practice Council, starting a practice and closing a practice, the role of the Legal Practitioners Fidelity Fund, which has also always been something that an attorney is expected to know, the liability and extent of liability in terms of the Legal Practitioners Indemnity Insurance Fund, as well as the Fidelity Fund. Your risk management, again, it is in terms of accounting, cyber fraud, FICA, RICA, face compliance and money laundering, as well as the POPI Act, and of course, the Legal Practice Act. Now, you will note that the Code of Conduct it emanates from our Legal Practice Act, and it is important that you look at the sections in the Legal Practice Act that would also be applicable as it relates to the above topics. In addition to this, it is also important for you to, you have about 1 month left, and based on the course material, there is a lot that you need to study, although it is nicely set out for you. So, it outlines for you very well how you need to practice, how you need to brace yourself when you are studying. I know people have different methods of studying, so it's good if you can develop a method for yourself where you don't cramp before the exam and you prepare well, go into the exam prepared well. And I think my colleagues have said this before, your reliance on past exam papers must not be what prepares you for an exam. And because it's an assessment, remember, drafting has many ways of drafting. So you must be able to draft in a way that you know the examiner understands what you are trying to relate. Understand the principles and learn to apply them. That way, you will have better time management and you will be able to prepare even better for the exam. And I think on that note, I can wish you the best for the upcoming exam. Study hard and prepare well. And all the best. Thank you.
Thank you very much, Hadira. Thank you very much for going through what the candidates need to cover in the paper 3 exam. These, as Hajira had mentioned, these are not new topics. These are topics that would always have been covered in these exams. They are in your course notes if you've gone through the LEAD or the Law Society training, as well as any other accredited training providers. So if you've gone through anyone that the LPC has accredited, these topics would be in your notes. So please go through carefully and make sure that you cover everything that's in the syllabus. I'm now going to hand over to Mr. Ashwin Trichamji, who's going to take us through paper 4. And then after that, we'll come back to paper 2, the Wills and Estates paper. But if we can hand over to Mr. Trichamji to assist us with the paper 4 bookkeeping exam. Mr. Trichamji, can you unmute yourself? Thank you so much.
Thanks, Melissa.
Thank you, sir.
Hi, good afternoon, everybody, and welcome to this session. My area of expertise or contribution to this afternoon session is probably the easiest one. But before I do that, and before I actually discuss the paper and the contents of the paper, may I just make a few introductory comments? And I get these comments. These comments are made as a result of questions that I'm quite often asked in the course of practice. The first question is, what's so important about accounting? Why must I waste my time with accounting when I'll just engage a chartered accountant to look after my accounts for the purposes of the legal practice rules and regulations? Well, my response there is very simple. The responsibility of looking after your trust account and meeting the accounting requirements is not that of your accountant, it's your responsibility. And if you have a smart accountant, and I must tell you that accountants are always very, very smart, and that accountant takes you for a ride by helping himself or herself from your trust account, and you don't know any better simply because you are too busy spending your time in court. And when you come back, you're tired and you're not going through your books of account and checking all the transfers that are taking place out of your trust account. And you eventually find, much too late, that your accountant has taken for your ride. It is not a defense for you to then say that, no, it wasn't my fault. It's my accountant who took me for a ride. You could very well be facing an application by the LPC for either a suspension or a strike-off, depending on the enormity of the problems in your trust account. So it is important for you to know accounts. My second, and I'm not selling accounting here because I've got a strong accounting background, but my second reason for emphasizing why accounting is a tool of trade, it is an absolute tool of trade for you. It is necessary for you to be a good attorney, to practice law and to give advice to your clients on commercial transactions. You have to have a knowledge of accounting. If you can't interpret a balance sheet, you don't know what an income and expenditure account is, you don't know what a cash book looks like, and you don't know how to advise your client on commercial transactions, you're going to be that much poorer. So for me, accounting should not be a subject which you should just prepare so that you just get through the board exams and get rid of it, as it were, as an irritation that you find in your practice. For me, it is a necessary tool of trade. And the stronger you are in accounting, the more easily will you be able to practice law, especially in court when there are contractual disputes and cross-examination of legal accounting practice documents are all in dispute. You are more equipped to deal with the cross-examination yourself, as opposed to sharing the fee with counsel. But that is just my sixpence worth, as it were, to all of you who might just think that some of you might think accounting is not really an important aspect of law. For me, and I've been in practice for a long time, accounting is a very, very necessary tool of trade for you to practice law. Right, that's just in upfront. Now, as far as the accounting syllabus is concerned, one of the nice things about accounting is that there are no exceptions to rules. There are no exceptions to the way accounting is practiced. It is a universal law that applies to accounting. The rules of accounting apply anywhere in the world. You can go to the North Pole, to the South Pole, to Russia, to the East or Far East. The accounting practice is the same. The requirements for recording, to keep accounting records, is the same throughout the world. So that makes it that much easier. Insofar as your responsibilities for this examination are concerned, what should you be really concerned about? Well, firstly, you must know a simple rule that governs the whole principle of accounting, and that's double entry. And then, of course, flowing from that, you must understand what a set of books are, consisting of a cash book, journal, and ledger. What's the purpose of each book? And then extending, which is the special requirement for a legal practitioner, is that you must understand that a legal practitioner is obliged to keep two sets of books. So you need to know what each set is, and that's the distinction between a business account and a trust account. Then you are expected to know how to write up a cash book. In other words, how do you make entries in your cash book? When you receive money, when you pay out money, what kind of entries do you make? And then, of course, the cash book is also important in this sense that you must also understand and you must be able to balance the cash book, which is an arithmetical exercise, but nonetheless, you have to do it. At the end of each month, you must learn how to balance your cash book. And extending from there, you must be able to ensure that the entries that you made in your cash book are correct. How do you do that? You carry out what is a bank reconciliation statement. Here, you are expected to be able to distinguish how you compare the entries. So you must have a bank statement and go and have a look at a bank statement. It's very important for you to see what kind of entries appear there. And then when you must know that you've got to compare the cash book entries and the bank statement entries and carry out the common process of ticking off the common entries. And then when you're left with entries, you must know what to do with those entries that appear in the bank statement that don't appear in the cash book. And you must know how to write up what is called a supplementary cash book. And then those entries that appear in the cash book that don't appear in the bank statement, you must know how to then calculate what we call a bank reconciliation statement itself. And of course, in the course of that particular exercise, you must know how to correct incorrect entries that appear in your cash book in particular. So that's as far as the cash book is concerned. Then you must know how to write up a journal. What kind of entry do you make in the journal? Yes, it'll broad definition, non-cash transactions, but you must know that journal entries, you record debits and credits and a little explanatory note and so on. So you must know the difference. And then once you know how to write up a journal, then you get to the most important book, and that's the ledger. How do you complete the double entry process by transferring or posting entries from the debit side of the cash book to the ledger in the credit side and so on? And that is very, very important. Once you understand that aspect, then the next thing you're expected to understand is how entries are made in the journal, cash book, and ledger all at the same time. And this is where you come across the most important aspect of the syllabus, and that is when you are instructing an agent or a colleague, attorney in another jurisdiction who then does some work for you on your instructions and then sends you what is called a statement of account. And how you will deal with that statement of account, effectively, how are you going to translate the entries that appear on the statement of account into your books of account? And that's where you require to really understand how to write up journal entries. And then the opposite as well, and the opposite is where you receive the instruction, right, from a correspondent. What kind of entries do you make in your cash book, in your ledger, in your journals, and so on? So that's what is commonly called agent's account. You got to know that extremely well. Now, I just want to caution you, for having been an examiner for many years, that year in and year out, when the question on either agent's account or correspondence account appears, a substantial number of you, candidates, will not read the question. The moment you see a statement of account which looks like an agent's account, you just go straight into it and you treat it as if it's an agent's account where you instructed the attorney in another jurisdiction, and then you answer it accordingly. Make your journal entries and the ledger entries in according to what you think is the answer. And in most of the instances, it is wrong because you haven't read the question carefully. The question is if the question is saying to you, you got the instructions from an attorney, and the statement that you see in your exam paper is a statement that you prepared to send to your correspondent, then of course, if you interpret it as an agent's account, you're going to get 0 marks for it. So please, 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 I'm saying it 3 times, read the questions. You got 15 minutes allocated to you for free where you don't write at all. You are expected to read the entire paper. So read the questions very, very carefully. And with regard to agents and correspondence account, please make sure you understand whether it's you receive instructions or whether you gave instructions. You must make sure that you distinguish that before you attempt to answer that question. If you get that's the second most important part of your syllabus. Thereafter, you are expected, of course, to understand what is the difference between what we call Section 86.3 investments, trust account investments, and Section 86.4 investments. Right, the one is where you invest on behalf of your client for the benefit of your client, and of course, the other one is where you invest trust monies for the benefit of the legal practitioner's fidelity fund. You must know that that's very, very important. And you must be able to deal with the investment in mandates that you get. Quite commonly, you're asked questions on simple questions like your client gives you an X amount and asks you to hold it in trust. And then the next question is you are instructed to buy shares in a private public company. Now we all know that that is not an 86.4 investment. It is simply an instruction for a disbursement to be made. So you must be able to distinguish between 86.3, 86.4, and a straightforward mandate for you to just buy shares on behalf of your client, which is very, very important. Of course, in between all this, you must know what we call collection commission, that appears in the agent's account and the correspondence account, the issue of 10% with a limitation that it has a maximum amount. And then once you know that, then the last part of your syllabus, so to speak, is really testing you on what we call property transactions, right? Property transactions, commonly called conveyancing transactions. And this is where your knowledge of the Section 86.3 and 86.4 investment is tested quite substantially. So that is in effect what you are expected to know, nothing more and nothing less. And then flowing from all these questions, we come back to the journal. You've got to understand and distinguish between what is a fee journal and what is a transfer journal and what an ordinary journal is. And how you use journals to rectify incorrect entries that are made in your trust ledger. Sometimes you debit the wrong client or you credit the wrong client. How do you correct that? You use your journal, and you must be able to use the journal to rectify entries, both in your trust account and in your business account. So effectively that is, and then we normally ask in the examination a small percentage, maybe 10 marks or sometimes 15 marks, on what is commonly called theory. Now, what kind of theory are I talking about? Well, the common theory that is expected of you to understand is the first one and most common one is the difference between input VAT and output VAT. And then flowing from that, more importantly, what are your obligations as an attorney operating a trust account with regard to your audit? So, you know, the audit has to be carried out once a year. And then what about from there, what does the auditor really look for in the fact that you have to extract what we call a trust trial balance 3 times a year? For how long must you keep your accounting records? Where do you keep the accounting record? And of course, the last one is how do you pay cash from your trust accounts? Or are you allowed to pay cash? And when you have to pay cash, how do you go about dealing with it by paying cash out of your business account and transferring money from trust to business? And that brings me to the last most important part, and that is transfer from trust to business. You must know and understand when you can transfer the money, what is the procedure to transfer money from trust to business account, and the opposite. When do you transfer money from business account to your trust account? And then the last one, which I consider to be very, very important, is how do you deal with a shortfall in your trust account? So in essence, what I've done is I've covered what you might commonly call a syllabus, but in accounting, it's nothing more than dealing with accounting entries, what kind of entries you make. So if you know what I've just gone through this, then you'll be quite comfortable. You'll be able to pass this paper. For me, all of you you've been through BCom, BA, LLBs, BProcs, and so on, all these degrees. If you've been through all that, then accounting should really be, in my view, humble view, a piece of cake, because it is very simple. There's nothing in accounting that's complicated. My advice to all of you for the preparation of this exam, yes, you can look at past examination papers, but that is only for you to become good at accounting by practicing and practicing. And the only way you can practice entries is by working out examples. So the more examples you work out, the more efficient you would become in identifying entries and, of course, making the entries in the examination. So that, in essence, it's what the accounting paper is all about. It's never any different. We don't ask you any tricky questions because there are no tricky questions, and it's the same questions all the time. So to all of you, good luck for the examination, and I am hoping that all of you will get more than 80% comfortably. This is one of the papers where you are quite capable of getting 100%, because if you get all your entries right, it's either right or wrong. So you can get 100%. So I'll leave you with that. Melissa, thank you very much, and good luck to all of you.
Thank you very, very much, Mr. Trikamji. Thank you for taking the candidates through the syllabus and what they will need to focus on in the upcoming examinations. I have posted a note in the Q&A. I've just asked that if there are specific queries, please can you email them through to us. That's info@lpc.org.za. So please send your queries for any of the papers through to info@lpc.org.za, and we'll respond to all of your queries in writing. There's a lot of queries that are coming through very quickly, and I'm not able to get to all of them in this session. So please, can you just send me an email and we will definitely assist you with your queries. So again, that's info@lpc.org.za. So thank you to Mr. Trikamji for taking us through paper 4. I'm now going to ask Mr. Singh, who has joined us now, to take us through paper 2 and syllabus and what is required for the wills and estates paper. Mr. Singh, can you unmute yourself, please? And then go ahead with paper 2. Thank you very much. Just unmute yourself.
Hello.
Thank you very much, Mr. Singh. Yes, we can hear you. Please go ahead.
All right. Thank you. Hello. Thank you, Melissa. And hello, everybody. All right. I'm going to take you through what is required for paper 2. You'll notice firstly that this paper is 2.5 hours. It's a 2.5-hour examination with a 15-minute reading time, which actually has made it easier for you to go through this paper and actually answer it. All the speakers before me have emphasized, and I'm going to do the same as well, that please read the questions. And I say that again, please read the questions carefully. And I say that because I think it is their experience, and has been my experience as well, that students sometimes, and very often, and I'll go straight to the liquidation and distribution account, answer or provide answers for sections of the account that are not called upon to answer. So you waste time, you waste valuable time in the exams. So I'd ask you again, particularly insofar as a liquidation and distribution account is concerned, to please read the question and only answer or provide answers for those parts of the question that you asked about. You'll notice as well that what's up on the screen now tells us the liquidation and distribution account is the largest part of the paper. It's a minimum of 60 to 70 marks, so which is a fairly decent amount devoted to that particular section of the paper. And the reason for that is very simple, and that is that when one attempts a liquidation and distribution account, and I'm talking in the context of the examination, you can weave into that many other sections or branches of a state administration. So you can bring interstate succession into it, you can bring testate succession into it, and you can bring almost anything, Surviving Spouses Maintenance Act, all can be woven into the L&D question. So that is why it forms such a large part of the question, the other question paper. The other 30% are related to I'll deal with the other topics, the other bullet points as we go along. But the other 30% is really other aspects of the course or the scope of the course that you're required to know. I think just before I deal with each one of the subheadings, I just want to add one other bullet point, if you might then like to, at the end of Matrimonial Affairs Act. I emphasize that it is necessary, it is absolute, it's actually indispensable, really, for you to have a knowledge of Regulation 5 of the regulations framed under the Administration of Estates Act. And I say that because Regulation 5 tells you in absolute detail, in absolute baby steps, if I might say that, as to how you go about drafting a liquidation and distribution account. And I'll be as blunt as saying that if you do not know what Regulation 5 says, then I'm sorry, you will not be able to frame a liquidation and distribution account, at least for the purpose of the examination. Forget about in practice, but at least for the purpose of the examination. So I emphasize, please read, and I do not mean that you have to know this off by heart. I do mean, however, that you've got to know what Regulation 5 says. For example, and I'll just give you a little sample of that. It says every account in terms of Section 35 shall have a heading which shall state, and it tells you what the heading it states, shall be followed by the liquidation account which shall, and it tells you what that must have. So if you read Regulation 5, firstly, it will set out the flow of the account and the sequence in which the accounts have to be shown in the liquidation and distribution account, and it tells you every single little step along the way. So that's the first thing I wanted to add to what is in front of you there. Then I also wanted to add that the questions in the papers that you would be writing will test your knowledge of the theory and the principles. And in most cases, you'd be asked to apply your knowledge of those principles and that theory into scenarios that you would be given in the paper in the form of a question. So it's very unlikely that you'll be asked what a particular section is, but you'll be given a scenario to test whether you know what a particular section says, so that you apply it to a practical scenario that you'll be presented with. Okay, so that's the second thing I wanted to say. And then I would also say that I think it would be advisable, and perhaps you might have a different method, but I think it would be advisable if you start each question on a new page, so that you do not have one question, one answer flowing into the other. It just, I think, makes things easier for you as the candidate attorney, and I think it does help the markers as well. So if it's at all possible, try and answer each question on a new page of your exam script. Then, yeah, one more thing I wanted to add, because I see it's been referred to under 3.2. It's been referred to under 3.2 of paper 3, where the bullet point says customary law, including land, customary marriages, recognition of customary marriages, succession, ownership of property, traditional leadership, refer to constitutional cases on those topics, including the Bear Judgment and others. Now, you will not find the Wills in Estate paper 2 section does not refer to any customary law, but I would ask you to at least acquaint yourself, for those of you who are not writing paper 3, for you to at least acquaint yourself with the different types, the types of customary marriages and the implications of each type of customary marriages. I mean, for example, what the implications, whether in or out, in a community of property or out of community of property, whether there can be accrual, whether there can't be accrual. So just acquaint yourself with the types of customary marriages, and you can add that to the list of the bullet points that we have. Now, going back to the specifics of each bullet point, the question, the drafting of wills, I think there are three main sections of this course that you would be expected to know fairly well, and that is the liquidation and distribution, the framing of the liquidation and distribution account, the Wills Act, and the Interstate Succession Act. Those are the three main props of this course. So insofar as wills are concerned and testate succession, you are required to know, and as it set out, there's section 2(1)(a), which are the formalities relating to the drafting of a will and the amendments. 2(1)(b), codicils and the court's overriding decision regarding the validity of wills. That's your section 2(3), which then allows one to make an application to the High Court to declare a will which does not comply with all the formalities as a valid will of the deceased. Then you're also then required to ensure that when it comes to the drafting of wills, you draft them in the simplest of language, so that you ensure that you give effect to the instructions of your client, because you could very well sometimes have a situation where you might end up with an interpretation of a will, and descendants or beneficiaries end up inheriting from that will which the testator never intended. So be careful sometimes the language that you use in drafting will. Keep it simple. And if you're asked, for example, to draft a particular clause to give effect to your client's instructions, then keep it within those instructions and keep the language, and this is my advice, to keep the language as simple as possible, because very often we are slaves to precedents, and we feel that if we don't use a particular word in a particular sentence of the will will be invalid. So there's no prescribed way of saying exactly how a will must be described, because everybody's wishes are different. So my advice is use simple language to convey what the question is asking of you, and of course what your client is expecting of you in the drafting of the will. Then there's a section which the third bullet on the next page, on page 5, is master estates. That was included after some discussion we had at the drafters meeting. Although it is covered under the Administration of Estates Act, at section 37 of the Act, I would encourage you to look at that section carefully and understand it. If you've got access to lead notes, it's very well explained in your lead notes. And once again, you'd be expected to know how to apply massing in a particular scenario that you may be given. So that's how you will not be asked what is Section 37. You'll be given a scenario, and you'll be expected to know what Section 37 requires of you for you to be able to answer that question. Interstate succession is a situation, as you all probably know, where somebody does not have a valid will or does not have a will at all. And the interstate succession will then determine how the estate of the deceased is to devolve. Insofar as that is concerned, my only advice to you is that you can only perfect that by doing examples after examples. It's like very much like mathematics and arithmetic. You just have to keep doing examples to be able to perfect it and understand it. The Administration of Estates Act, well, that's a general heading there. Then we get to the drafting of the liquidation and distribution account, and that includes all the accounts in Regulation 5. And I stress again, you must have a knowledge of what Regulation 5 says. And if you don't, then unfortunately, you will not be rewarded with marks because there's no shortcuts insofar as that is concerned. Regulation 5 is very specific about its requirements, and in your answer has to be as specific as well. So again, I would say to you that although you have been told to keep away from past exam papers, and I support that view, but I think insofar as knowing what an account looks like and what you're required to disclose in the account in compliance with the Regulation 5, from that point of view at least, look at past exam papers and you will see how an account is set out, what is required insofar as compliance with the Regulation 5 is concerned. Once again, your lead notes are fairly detailed. And if you look at your example in the lead notes, it's a fairly extensive example. That will give you a lot of help as well. Calculation of estate duty and the estate duty payable. Well, of course, that falls under the estate duty addendum, which is an integral part of the account. Once again, there is a lot of literature available, and particularly your lead notes are fairly comprehensive insofar as assisting you how to go about doing the addendum and calculating the duty, if any, that would be payable. Knowledge and application of the relevant legislation, you're required to know, and I think that list has been shortened, and I think everything that's ticked there is what you are expected to know, at least for the purposes of the exam. The Wills Act, Interstate Administration of Estates, Estate Duty Addendum, Maintenance of Surviving Spouses Act, and the Matrimonial Affairs Act. Yes, and particularly as there's Section 5.3b. And to that, I've added the Regulation 5, and I've added a knowledge of customary marriages. And yeah, that's about all I've. Oh yes, of course. Then have some regard to what is said in the lead notes that you have access to. I think that the type of papers that you would be facing, like everybody else said, is not there to trick you, but at least to test whether you have a working knowledge of wills and estates. We do know that there will always be a supply of work. And so, unfortunately, insofar as wills and administration of estates is concerned, simply because people must die. So there'll always be that stream of work coming to us. And I always encourage people to make this a budgetable part of their income in their practices. So it's a good branch of the law to specialize in, because from there you get conveyancing spin-off, you get other work that comes in from the family if you've served them well. So I always encourage people to make administration of estates an important part of their work. Going back to the exam situation, I think that the papers have been drafted on the basis that you'll have enough time to complete the paper. You've got 15 minutes, which is a reasonable amount of time to absorb and go through the paper and settle your nerves into it. And I'm quite certain that you would, with the average person, would be able to go through this, pass this paper quite easily. Melissa?
Thank you very much, Mr. Singh, and thank you for taking us through the syllabus and those topics that are listed there. Thank you for explaining to the candidates what they need to know for the exam. There is one question that popped up. It says, will we need to calculate the accrual for out of community of property purposes? Is that something that you can address?
Yes, yes. You'll notice that in the bullet points that you've been given, there's no reference to accrual. And I can say this to you quite boldly, even on this platform, that you'll not be expected to calculate an accrual claim. If anything at all, you'd be given the amount of the accrual claim, which is either for or against a deceased estate. So you might have, in your other branches, in the other study of the law, you might have been, you would have come across how to calculate an accrual claim. But for the purpose of the administration of the estates and the scope of this course, you won't be required to calculate an accrual claim.
Thank you very much. And one final question for you, sir. It just popped up here. How important are fiduciary assets for this exam?
Well, they are important as every other asset and for every exam, because many people do own fiduciary assets. So they are an important aspect. And as you can see, it's provided for in Regulation 5. So it's as important as the assets that are normally owned, or assets that are normally owned by people. So you can't distinguish or say one is lesser important than the other.
Thank you very much, Mr. Singh. I think you've covered the two questions that we had pop up here.
I have. I just wanted to. I'm going to ask the question, but I don't know whether you can provide an answer, Melissa. Is it? Am I correct in saying that the candidate attorneys are entitled to take their calculators into the exam room?
Yes, absolutely. They can take calculators in with them, but it can't be their cell phones or a smartwatch or anything like that. It just has to be a plain calculator. But candidates do take them in for paper 2 and 4, just so that they can do these calculations correctly.
All right, fine. No,
thank you very much. Thank you, Mr. Singh. You've addressed those two questions. Thank you very much for that.
And if there's any other questions that might arise later, you can just email Melissa and I will do my best to try and answer them and come back to you.
Thank you very much, sir. Yes, so what I've been recommending is that candidates who have questions from this forum, email info@lpc.org.za, and then if there are specific questions, we will forward them to you for a response. So thank you very much for that. Thank you for your time, sir.
Thank you. Thank you.
Just the last thing on one of our papers here, just the query on for Mr. Trichamji, if you're able to assist us. The candidates have asked for paper 4, the awarding of marks, where, and this is something that does come up. Candidates are asking, are there method marks? What happens when they get their answers wrong or their calculations wrong? Are they still able to be awarded marks along the way? Mr. Trichamji, are you able to assist us with that query?
Yes, sure, Melissa.
Thank you, sir.
First of all, just to give you an idea of marks, the question on the cash book, followed by the reconciliation statement and the supplementary cash book and so on, that normally carries between 10, 15 and 20 marks. And then you have a question on the correspondence account and vice versa, the agent's accounts. That ranges between 30 and 40 marks. And then you have the question on property transaction, which also is sometimes replaced by the investments of trust monies in terms of Section 86.3 and 86.4, as I mentioned. That normally carries about 30 marks as well. And then the last part, which is what we might call the theory, that carries between 10 and 20 marks. That's the mark allocation, and it's a guide. It's not necessarily exactly as I've said it. It could differ slightly. Insofar as your entries are concerned, examiners who mark the accounting paper are looking for entries. So if you got an entry correct, but you got your arithmetic but mixed up, many of the examiners, if not most of them, and if not all of them, they will give you a mark because it's a question of testing you whether you know the entry. So if you got your arithmetic wrong, you may lose a portion of the mark, but you will still get some marks for the fact that you made the correct entry. So I think that is the best I can do at this stage.
Thank you very much, Mr. Trikamji. That does help. I think the candidates are worried that if they get something wrong and they carry forward a wrong answer, if they will lose all their marks. But thank you very much for addressing that. There are a lot of questions that are coming through. I am going to ask everyone to email info@lpc.org.za. What we will then do is we'll compile a list of questions. So if you're able to send your email to us within the next day or two, then we'll compile all the questions that we receive on email and we will then share it with candidates. Please follow our social media pages because it's easy for us to post on social media and for you to get the information. So where there are specific questions that are asked and it would benefit the whole group, that information will be shared with everybody. So please don't panic if we're not able to address your question now. We will do so on email and we will share the information with the group when we have all the answers to the questions that are being asked. So please, I see some emails have already started to come through. That's great. Please keep sending them. And within the next couple of days, once we've received most of the queries, we will then address them and then post information to candidates as required. So I just want to thank the presenters who were with me today, who took you through the syllabus and what you need to cover for paper 1, 2, 3, and 4. These are the papers to be written on the 21st and 22nd of August. The syllabus that you have in front of you is only applicable to the August exams. So please make sure you've printed that document, you know what you registered for, and you work your way through the document. Like we said, please send any queries you may have through to me. We will compile them in a document and then share that with candidates. Please follow our Facebook pages so that we can, when we do post a notice, you're able to pick it up quite quickly. The purpose of this session was to take you through the syllabus that has been presented and to show you what you need to focus on for the exams. As we have stated, only what was covered in the syllabus will be in your exams. So if you're not sure and it's not in the syllabus, it means you don't have to cover it. So the point of this session was for us to take you through that document to make sure you know what to focus on and also for you to know what you can leave out. The courses, I know I see a lot of questions where people are saying, candidates are saying, where can we get the information from? You can go and use exam preparation courses. You can go through private institutions. We do see a lot of people offering tutoring and courses, but please be very careful and very mindful when you sign up for these programs. There are a lot of organizations that try and take advantage of candidates at this time of the year, where they charge you a lot of money and they don't provide the assistance. At least with your syllabus now, you can ensure that the training that you're receiving is in line with what is going to come out in the exams. Please remember as well that NADEL run exam preparation classes that are free for you to attend. So you don't need to pay anything. It's LPC funded, which means you register for free and you can attend either in person or online training. So if you would like to attend those classes, go along to the NADEL website or to their social media pages and make sure you sign up for those exam preparation classes, as they are free. With the classes, you also get notes and material provided, and they teach you through the syllabus that we've shared with you. So please, if you are using exam preparation courses, just make sure that you're not going through training providers who are going to just take your money and not provide the value that you need. If you need to, you're welcome to go through NADEL, who offer these classes free of charge. So just go along and register. There are classes coming up. I know in August there's all the online classes. So please have a look at what you need to attend and then join them. So as I mentioned as well, there are a lot of questions that have come through. Our role today was to take you through the syllabus and to show you where your focus needs to be. Candidates have complained previously that you didn't know what to study or where to even start. And hopefully, with the guide that we've given you, as well as the session we've had today, you know where to refer to and what you need to prepare. There will be another document that's going to be published, a syllabus document, towards the end of this week, but this does not apply to you. So the document that you have in front of you, the 10 pages of the syllabus, that's what you need for the August exams. There will be another document that's gazetted, but that is for our 2025 syllabus. That's for comment. You're welcome to comment on it if you like, but that is not for these exams. Please only use what we covered today in order to prepare. There will be no other documents that you need to use in order to prepare for the exam. So use the syllabus only. As we've mentioned to you, you need to learn your theory and practice. All 4 of these exams are going to combine theory and practice. There are drafting in each of the exams, so you need to be prepared there as well. The pass mark for these exams is 50%. If you receive 40 to 49%, then you're entitled to an oral exam. Less than 39% and below is then a fail mark. You will have the opportunity to apply for a remark if you choose to. When you sit for your exams, when you sit down, please make sure that you're a little bit early. If the exam starts at 9 o'clock, we recommend being at the venue from 8, so that when they open the doors, you can go in and get comfortable and set yourself up so that you're ready to start the exam promptly at 9 o'clock or whenever the exam starts. If you arrive late for whatever reason, you will not be given extra time. So for a 9 o'clock exam, if you only walk in at 10, in some venues you're not allowed in. Where they decide to allow you in, you will not be given that extra hour that you've lost. So please make sure you're there early, that you're sitting, you're comfortable, and you're ready for the start of the exam. One of the questions in the chat group I can see here is candidates are asking whether they can answer the paper in any order or whether they need to go 1, 2, 3. For the questions, you can answer in any order. So you can choose what section you are most comfortable with or what question you're comfortable with and answer that question first. But please make sure that you clearly state the question number. So if you're starting with question 3 and then question 7, make sure you indicate what question you're answering, because if you write question 1 but you answer according to question 3, then unfortunately we're not going to give you any marks for that. It's not for our examiners to try and figure out what you were trying to say. Then very importantly, please make a note of this. You must bring original ID with you to the exam. A photocopy or something on your phone will not be sufficient. You can't show us a picture on your cell phone. You cannot have a photocopy, and you will not then be allowed entry into the exam. So even if you're standing there ready to go in and write without proving that it's you that's standing in front of the exam venue, you will not be allowed to write that exam. So please, you must have an original ID. You'll be asked to present it, and then you'll be given access into the exam room. As we mentioned, please send all your queries along. I can see 4 or 5 queries have come through so far. The email address is info@lpc.org.za. Please, for any assistance and queries you have following the session we've had, please send that through to me. We will be responding, and we will do so once we have a number of queries. If it applies to all candidates, then we will be responding so that everyone can benefit from the answers. Again, I want to just ask you to be mindful of who you use for exam preparation. Study in groups. If you've got friends or colleagues, it's always great to study in a group. And if you go through exam preparation classes, the NADEL one, like I said, is free, and it is funded by the LPC. So we aren't going to be able to cover all the questions today, but rest assured that you will get your responses. You have a month to go before the exams, so please work through the syllabus document and come back to us if there's anything more that you require. It's now just for me to wish you all the best with your preparation, now that you know exactly where your focus needs to be for each of the exams. You are LLB graduates. You've come this far. Please don't underestimate yourself, because you know more than you give yourselves credit for. So take your time, study through the syllabus, go through the exam preparation classes, those that are offered by NADEL and others, where you can get the material that you need. And if there's anything you require, you're more than welcome to reach out to us, where we will assist you. So good luck to everyone. Thank you for joining us today. This session will be posted to YouTube if you want to go back and follow it again. Please reach out if you need us, and good luck with your preparations and all the best with the exams. We are all rooting for you and hoping that you do well. So thank you, everybody, and our session is now adjourned. Thank you.